Okay, we are at the top of the hour. I want to welcome everybody to this presentation with the Golden State Pool Trust. We are recording this here, and hopefully, if the recording comes out well, it'll be available on our YouTube channel. Um, our- for this presentation, we are going to cover an enormous amount of materials in this. So for the presentation itself, I'm going to plow on through and then we're going to hold questions until the end. So we would like you to, when you pose your questions here, we'd like you to do that in the question box there. Amy is monitoring the questions, and once again, we'll get to it when we get to the end of the program. The program is scheduled to run for an hour and a half. I feel pretty confident that will happen. One of the things you'll notice is that as we go through this is there's three codes here for those of you that are applying for MCLE credit. And once again, it's really important that you get those codes, and we'll have instructions about how you can record those and send those in to get MCLE credit under the state bar. Um, uh, Also, for those of you that are watching, we have a pretty ambitious schedule this year of MCLE programs that we will be doing here. So if you are not on our mailing list, the best place to go is gspt.org to attorney resources. And you can not only sign up for future programs, but most of our other programs here you can easily access. Last thing, end of next month, our next program will be with the folks from CalAble. So we will be revisiting CalAble again. And once again, we have a pretty ambitious set of programs coming up. I'm going to go ahead and get started. As I said, we have a tremendous amount of materials to cover. Um, One thing as we get started, for those of you that are doing this for credit, this program has been approved for 1.5 units of MCLE credit by the California State Bar. There are three codes that are going to be announced during the program, and you need to record those to verify your participation in the class. Once again, to receive MCLE credit, please download the credit form at gspd.org/attorney resources and fill in the proper codes for each section. If you do run into problems, you can always email amy@gspt.org. So let's plow through this. So we're going to cover a bunch of stuff today. In fact, we're going to cover a lot about different kinds of benefits. So we're going to talk about housing basics for SSI recipients. We're going to talk about how do you determine the fair share if they're part of a household under SSI rules. We'll be talking about housing rules under Medi-Cal and some of the complications we've run into since adapting to the AB 133, which has eliminated the resource rule. Something relatively new for this presentation is we'll be talking about the HOTMA regulations for those that are on HUD subsidies. We'll be talking about ABLE accounts and special needs trusts and housing. So that is a lot to cover. So let's get through it here. So just talking about benefit basics here, once again, whenever you are counseling somebody on housing or anything dealing with benefits, the first thing you got to do is figure out what benefits they're on. And as we're going to see, a lot of the rules here are very different from program to program. So as we're going to see, the rules under SSI are vastly different for those that are on Medi-Cal here and HUD and the other programs. So this is one of the reasons why it's so important to cover, as many or to make sure you know what benefits they're on and then apply the right rules here. So with that, let's start off with SSI. As we all know, SSI is a federal program administered by the states and is based on showing a sufficient evidence of disability and financial need. It's intended to pay for food and shelter and nothing more. And that's a really important concept. And if an SSI recipient gets assistance with food or shelter, there could be a reduction in their benefits. Now, we're doing this in California so for those of you that are watching out of state, I know the numbers aren't going to line up for you, but we do have a state supplement. So in 2024, when we're recording this, the SSI rate in California for a single person is $1,182.94. By the way, in your handouts, there is a sheet, kind of a cheat sheet on different benefits and benefit levels and income levels and things like that. I'm hoping you'll find that useful not only for this program, but in your practice. So let's talk about SSI recipients here. To get SSI, there's a three-part test. The first is that you have to meet the definition of disability. Okay. The second test, or you have to be aged, you have to be over the age of 65. The second test is that there's an income test that determines how much you receive. And the third test is the resource test. So just a quick review as we go through this. For SSI, there are three kinds of income. Just covering these really quick. The two that's going to be relevant for what we're talking about today is if you get unearned income, if you get any cash, your benefits will be reduced dollar for dollar after the first $20, which is called the $20 disregard. We're going to see that disregard come up over and over and over again. But the problem is if you give somebody on SSI cash, once again, in most cases, it will reduce their benefits dollar for dollar. Just to cover it, if you earn it, you lose $1 for every $2 you earn after the first $65. The one that's most relevant today is if an SSI recipient actually receives direct assistance for food or shelter, then they could actually get a reduction in benefits based on what's called the concept of in-kind support and maintenance here. And the reduction is 1/3 of the federal benefits plus $20, the disregard. So currently, for instance, this is what's called the presumed maximum value. The number in 2024 across the country is $334.33. There is a cost of living adjustment. So in most years, in fact, I can only think of 1 year this didn't happen. That number is going to change slightly every year. So, and we're going to see this slide about 3 times, but when we're talking about what is in-kind support and maintenance, they only count 10 things. So I'm going to list them off one time. After that, I'm going to assume you guys can read. So if somebody receives food, assistance with a mortgage payment, including property insurance payments, real estate taxes here, rent, heating, fuel, gas, electricity, water, sewer, or garbage removal. If they get that outside assistance, whether it's from a trust or a family member, wherever they get it, it'll reduce their benefits dollar for dollar, capped at what's called the presumed maximum value, which is the $334.33 this year. So the last rule is the resource rule. SSI still has a $2,000 resource rule. And if your resources exceed $2,000 at the first moment of the first day of the calendar month, you lose your eligibility for benefits. Now, there's a couple of big exceptions to that, especially when we're dealing with housing. So keep in mind, a person on SSI or Medi-Cal can own a residence that they live in of any value. Okay, and we'll be covering that as time goes on. The other resource exception that applies to what we're going to talk about is that as of March of 2005, an SSI recipient can have all the household items they like in the household, regardless of value, as long as you're not holding them for their intrinsic value. This is a pretty liberal rule. So with that in mind, let's go to our first MCLE code. So our first MCLE code, for those of you that are watching for credit, is 6835. Keep in mind, to download the MCLE form, you can go to gspt.org/attorney resources and download the proper paperwork. If you don't have it, write this number down. Okay, so moving forward. So let's talk about SSI and living arrangements. And I think it's critical to understand this when you're counseling people about housing, when they're on SSI. Now, the materials that we're going to cover are going to come straight out of the Social Security website. And this link is in your materials as well. And actually, this is a pretty useful website here called Understanding Supplemental Security Income Living Arrangements. So let's see what it says. Now, I copied this word for word. I did not add the California supplement, so we're working with federal numbers. But what I'm interested in is going through the concepts. So in this first example, the example is if you have an SSI recipient who's living alone in an apartment. So let's say we have that situation and a sibling pays your rent of $800. Isn't that a nice sibling? By the way, it could be the trustee of the Golden State Pool Trust. We probably would come up with the same result. When they talk about they're talking about the Social Security Administration. We limit how much of the $800 we count by using what's called the presumed maximum value. So this is a good example to go through. How do they look at the presumed maximum value, which is equal to 1/3 of the federal benefits plus $20. So the way this works is that to figure out the presumed maximum value, they take the benefit rate and add the $20, which gives us the $334.33. Then, once again, when you apply it, if you haven't used your $20 disregard before, when you apply it, they will remove the $20 disregard, meaning the amount of the actual reduction will be $314.33. Meaning in this situation, under the federal benefit rules, the PMV reduction in this case, because once again, that nice sibling paid the $800 here for the rent and paid the landlord directly, is the result that we would end up with is $628.67. Now, by the way, you can only use the disregard once. So we'll see an example where they don't use the disregard. Second example, you live in a house of your own, but you get some assistance from a friend. So in this case, you live in a house on your own. Your only income is SSI. But let's say you have an adult child that pays your electric bill of $100, your phone bill of $50, and your television bill of $75. How does that work? In this case, what they're showing is that because the telephone bill and the cable are not on the list of what they count for in-kind support and maintenance, they don't count that. The only thing they're going to count is the electric bill. And they're removing the $20 disregard. And what happens in this case is the benefits are reduced by $80 a month. Okay. So this is a good example, once again, of how Social Security actually applies the PMV rule. Here's another one. And by the way, we have a link to a video specifically going through trying to figure out what a fair share is if you're in a household. Okay, so in this example, suppose that you live with your siblings, with two older adults in a home that your sibling is buying, and your only income is SSI, and there's 4 people in the house. So once again, in this situation, the mortgage is $700 here, and the average monthly bills are $200 for electricity, $100 for water and sewer, and $600 for food. So if you add that all together, and those are all things that account for ISM, the total amount is $1,600. So it's actually rather simple. You take the $1,600, you divide it by 4, and that's what Social Security calls your fair share. If the SSI recipient pays the full $400, out of their SSI, or as we're going to see out of an ABLE account later, you would get the full amount of your SSI check. If you pay anything less, it's going to reduce your benefits dollar for dollar, capped at $334.33 less the $20 disregard. This is a pretty good example of how they calculate household expenses. I will tell you, I forward this to beneficiaries and professionals all the time here, because it's a lot easier when you look at Social Security and how they do it with these examples than anything else. For our last example, let's say you live in a house rent-free, which is owned by a sibling here, and you receive $300 a month in Social Security benefits. That could be Social Security retirement, it could be Social Security disability, and all of that. You pay all the utilities and buy all the food. And they determined that the house would rent for $900 on the open market here, if the sibling were to rent it out. Okay, so what they do in this case is they're subtracting out the $300 of Social Security retirement, and they're subtracting out the $20 disregard. This is going to give you an example that you only get to remove it once, which means a $280 reduction here in the SSI for a total amount of SSI of $663. With that, because once again, the sibling is letting you live rent-free, and the rent that they've determined to be $900, they reduce the benefits dollar for dollar, capped at the presumed maximum value rate, which in this case is $334.33, because you don't get to take the disregard twice, meaning the total amount of SSI you would receive would be $328.67. Okay. So I find these really useful when you're trying to go through this concept about SSI, paying rent, what's the value of things. And I think, once again, there is a link in the materials that we gave you here. And I will tell you, that's something you should bookmark. It's something I use with beneficiaries and families and professionals all the time. Now, let's jump up to something a little bit different. What happens if we have a situation where somebody is not getting SSI, but they are getting aged and disabled federal poverty level or similar Medi-Cal, right? So in most cases, and I think there's cases that we as planners really need to look at. What are the values of the different programs? And in some cases, maintaining the Medi-Cal isn't really that big a thing. I have a lot of cases, especially if there's attendant care and long-term care, where giving up the Medi-Cal would just be devastating. So the first question we have to analyze is whether they're getting their benefits, their Medi-Cal, based on being categorically eligible for SSI, or are we under different rules? So for many beneficiaries, and sometimes this drives me crazy, if you get at least $1 of SSI, you are categorically eligible for Medi-Cal, because we are what's called a 1634 state. I know we have folks watching from other states here, and I believe there are still 10 states where you are not categorically eligible. here. So if you are in what's called a 209B state, the rules are different. But maintaining that $1 of SSI is not the only way to get the Medi-Cal. It's not always even the best way to do it, depending on the situation. I have seen people go through enormous amounts of headache to maintain that last dollar. And I think in many situations, they're just working too hard. Medi-Cal eligibility can be maintained independently. And what we're going to cover for the rest of this segment is what if they're not getting SSI, but they're just getting Medi-Cal? So, of course, the granddaddy of all these is the SSI-based categorically eligible Medi-Cal. But the other way to maintain it is aged and disabled federal poverty Medi-Cal. That's the one where we normally, for folks that are getting in-home support services and that kind of thing, that's what we're usually looking at. Share of cost Medi-Cal that we're going to go through quite a bit. The 250% working disabled program, which we're not really going to cover today, but it's a magic program, I'll tell you, for many folks here, if they can even do a little bit of work. Here, and the Medi-Cal waiver programs. For this, here we're going to be talking about aged and disabled federal poverty level Medi-Cal. To qualify for that, you have to be either aged, which means over the age of 65. I'm 72. I'm not so sure that I agree that over 65 is aged, but I'm not Social Security, so what am I going to say? But as of January 2024, California eliminated the resource limitation. So you can now have unlimited resources and still remain eligible for Medi-Cal, but the income rules still apply. So if your countable income is greater than $1,752 for an individual or $2,371 for a couple, then the Medi-Cal recipient would be subject to a share of cost. I mean, I'll tell you something I learned early on. A great advocate, might even be watching today, a fellow named Daniel Fortuno. He does classes on this, and the way he talks about it is aged and disabled Medi-Cal without a share of cost is the good Medi-Cal, and aged and disabled Medi-Cal with a share of cost is the evil Medi-Cal. So we want to explore how to avoid the evil Medi-Cal. And when you see how the share of cost works, it is truly evil. Okay. Now, I got this and I copied it word for word on a great article here from the California Health Advocates website. You can see the link there. And for those of you that are watching for credit in the materials, that link is there as well. So I'm just going to go through the highlights because oftentimes share of cost is very misunderstood, and especially since that we no longer have a resource limitation, it's more important than ever to really understand the income rules. If your monthly income is higher than the limits to qualify for SSI, then you still may be eligible for Medi-Cal under the share of cost for Medi-Cal with a share of cost. A share of cost isn't really a premium. It's the amount of medical expenses you are responsible to pay for before you get full Medi-Cal coverage for the remainder of that month. So what happens is Medi-Cal subtracts $600 if you're an individual or $934 for a couple from your monthly income and any other health insurance you may be paying. Okay. So for example, if you have a monthly income of $1,800, Medi-Cal subtracts $600 here for a share of cost of $1,200. The reason that we're doing the share of cost is that the amount of income the benefit recipient is getting is greater than, and I'm actually the $1,752 that is current for this year. I had to look it up myself here. So $1,800 is greater than the 1752, then once again, the person is subject to share of cost. Now, Getting back to housing, we have a pretty unique and I think sometimes bizarre rule in Welfare and Institution Code 50509A, which states that income in kind for any support or maintenance received in kind from a person other than a responsible relative for housing, utilities, and food here is going to be considered in-kind support and maintenance, but they only count it if the entire amount of the item is provided. So here we have uh, a table that is still valid. It's been in place since 2009. So the way this basically works is if you're a single person, for instance, and let's say, for instance, the Golden State Pool Trust were to pay your entire rent, then you would need to add $153 to your countable income here. And if that keeps you under share of cost, that's fine. But as we're going to see, there's a danger it will throw you into a share of cost. The same thing for utilities, food, and they no longer count clothing. We expect that the food will go away, the rule for SSI. And if that happens, our expectation is the food ISM will no longer be counted for Medi-Cal because California's basically followed the rules for SSI as far as what is counted, just not how it's counted. So, as an example, let's say Barbara wants her Golden State Pool Trust account to pay her rent of $2,000 a month. She receives $1,700 a month of SSDI. Well, she's going to have a heck of a time doing that, isn't she? So she also receives Medi-Cal under the Aged and Disabled Federal Poverty Level Program. Okay. If the Golden State Pool Trust were to pay the $2,000, then her countable income would be $1,700 plus the $153 that we found from the table because we paid the entire thing. So, therefore, her countable income would be $1,853, throwing her into share of cost or the evil Medi-Cal. Okay. So since once again, it's greater than the 1752, we're in share of cost here. And once again, this just illustrates what I had already told you. Now, just as an aside, let's say it didn't. Well, then it would be okay to pay it. Here, the key is just to pay the entire thing here. But once again, we need to be really cognizant of this because you can see where the share of cost very much eliminates a lot of the value of the Medi-Cal. Now, if she were to pay $20, and there's no set amount, you could pay $1, but why get greedy? I mean, you probably could pay a barley corn, but that would be confusing. So if she pays $20 of the rent out of her own pocket, and the trust were paid to pay the remaining $1,980, then the payment of rent does not affect her eligibility. Now, if you have a situation, maybe the landlord isn't really wild about getting a $20 check and a $19.80 check. One way to do that is to have her pay the $20 back to her trust account or to her special needs trust just to show that she made the contribution and have the trust pay the entire $2,000. But hopefully you get the concept as we go through this. So let's talk a little bit about ABLE accounts and housing for SSI recipients. Something to mention here, next month we will have the folks from CalAble also on our GSPT playlist. We have lots of materials about ABLE. So we're not going to go through the ins and outs of ABLE, but we do need to remember that currently the disability has to begin before the age of 26. And starting in 2025, states will be able to raise that to age 46. My expectation is CalAble is on it. So that number will still go up. We still have that limitation. With that in mind, let's see how this affects housing. Now, here's our old familiar table here going through the different types of income. But we have to remember that for folks that are on SSI, and as we're going to see, ABLE has values in other things here, that if the SSI recipient gets assistance outside assistance for their housing, whether it's from a family member, whether it's from a trust, wherever it comes from, benefits can be reduced dollar for dollar, capped at the presumed maximum value, which is $334.33. So let's plow further. Now, as far as can you use an ABLE account for for housing, it has to be a qualified disability expense. The actual a limitation of what is a qualified disability expense is pretty broad, but whether it's broad or not, housing was in the legislation so clearly using an ABLE account to assist with housing. That means rent or utilities or anything along that line is not going to reduce benefits at all. So here's an example. Let's say Belinda is a Golden State Pool Trust beneficiary and has been disabled from birth. So we don't have an argument about whether or not she was disabled before the age of 26. She receives $1,182.94 in SSI monthly. A major expenditure for her and everybody else here is housing and utility payments here. And she'd like to move into a nicer apartment that would cost $1,400 a month. So to do that, she's going to need some assistance. Now, if her friendly trustee, hey, that's me, were to give her $1,400 a month directly, that's not going to work at all because it's going to count as income as unearned income here and would eliminate her SSI completely. If the trustee were to pay the landlord directly, then it would be ISM, and we would take the reduction of $334.33, which is what we've done for decades. But if the trustee were to contribute $1,400 a month, and you could do it monthly, you could just do it in one fell swoop into their ABLE account. And in turn, if Barbara were to use her ABLE account to pay the landlord, there would be no reduction at all. So as we can see, what's going on here is that we are, she's able to keep that $334.33. And I tell you, for somebody living on SSI, that is a chunk of change. I mean, that actually works out to $4,000 a year here, which, is serious funds. But somebody who's living on these meager benefits, $334 means a big difference when it comes to quality of life. Now we come to our second MCLE code, which is 2221. Once again, 2221. Okay, let's plow ahead. Here is the new kid on the block. Okay, HOTMA here and trust. So HOTMA stands for Housing Opportunities Through Modernization Act of 2016. And you go, 2016? Why are we talking about this in 2024? Well, it took a long time to get this thing up and running. So a little basics about Section 8 or HUD programs. Section 8 is a subsidy program for low-income individuals to assist in monthly housing costs. Under Section 8, the household pays a portion of the monthly housing costs based on the income of the household. This usually equates to 30% of the household's monthly adjusted income. The Section 8 subsidy could be site-based, meaning attached to a particular unit and not assigned to a specific person or household, or it could be a subsidy granted for a particular person and household applied for qualifying for rental property, which is called the voucher program. For our purposes of how do they count income, the rules are the same. To be eligible for Section 8, here, you have to have very low income um, and have income at or below 50% of the area median income. You have to be a citizen or a non-citizen with eligible immigration status, and you have to be in good standing with the housing authority. So don't upset the housing authority here. So now, part of what HOTMA did is before this, there were no asset limitations in HOTMA. So part of what happened was there was a compromise here to try to divert more money for subsidies in exchange for an asset limit. So they set the asset limit at $100,000 with a cost of living adjustment. Here. And HOTMA, even though it was passed in 2016, the final regulations were not issued until February 2023. I'm actually on a couple of committees that are working on HOTMA rules and income. And as we're going to see, despite the fact that a lot of work has gone into this, there still are a lot of questions coming up about, what they count and what they don't count. So let's go through this as best we can. As far as it's concerned, just generally under HOTMA, all investment income is going to count. But if the household assets are less than $50,000, they have what's called the self-certification process. And, whatever you declare is what they're going to accept. It can be zero. If the assets are over 50,000, there's an imputed income passbook rate, which is currently 0.4%. Also, they look for whether or not assets were transfers here. And if there was a transfer of less than fair market value, there could be a 2-year period of either ineligibility or imputed income. Once again, we're not covering that today. We will be covering that in greater detail. We're mostly interested in trusts and housing. So one of the things that they don't count, and here is they don't count proceeds of litigation from a personal injury settlement that caused the disabling injury, okay, or civil rights violations. And as we're going to see, there's a pretty generous rule that came out for structured settlements. Lump sums are not counted. That pretty much carried out from the old rules. They don't count the value of IRAs or qualified plans, but they do count the required minimum distributions. They also do not count distributions from 529 plans or ABLE accounts, and they don't count federal and state tax refunds. Now, I pulled this off of the National Structured Settlement Trade Association website here, who has been doing a lot of lobbying around this here. And one thing that, they lobbied for and they believe that they got clear direction from is that that if you have a structured settlement that came from either a civil rights settlement or a personal injury settlement that contributed to the disability, then structured settlements are not counted. There are a number of situations where if the person is not on SSI and merely trying to keep qualified for their HUD, you can see where folks might be able to structure their way out of the problem. So what is the effect of increased income? And I will tell you, I see people, I think, working too hard to make sure that they don't produce any income. The real fact is if your countable income goes up, if you put it in investments, yes, your rent may go up by a third of the increase, but you get to keep the other two-thirds. So I think it's kind of cutting off your nose to spite your face to, for instance, not invest the funds because, well, now you're getting no value of the investment at all. We're talking about somebody holding something outside of a trust. We'll be getting to trust in a bit. Here, if the income exceeds the affluent limit for the location, there is a 24-month grace period. You will be given the option to pay fair market rent, and there are hardship exceptions. In most cases, it's not fatal if the income does increase. And I will tell you, just for myself, if you screw up somebody's SSI, that's a real problem. For those of us that are in California, if you screw up their eligibility for a HUD program, including Section 8, that is a catastrophe. There are waiting lists to get on waiting lists. And once again, this is something that for those of you that are attorneys or fiduciaries or working in this field, this is an area where you need to really monitor very closely here. I think most of these rules are pretty straightforward, though we do have some clarification that we're still seeking even to this day. So just to go back this, retirement accounts are not considered assets, although the RMDs are. Able accounts are not considered assets. So for instance, if somebody is assisting funneling funds to an able account, will make it not countable. Assets in a trust that is not controlled by a family member doesn't count here. Proceeds from an accident that caused, and by my reading, although we're going to see further clarification, contributed to the disability are not assets. And proceeds from civil rights litigation are not assets. Things that are necessary, personal property are not assets, very similar to SSI and Medi-Cal, and tax refunds are not considered countable assets. Now, when we get down to trust, here's what we know. Trust principal is not counted. So if you make distributions from income, it's not counted, but income is. And once again, on the committees I am working on, that includes, if, for instance, if there's a trust, that includes any administrative expenses as well. So we're talking about DNI, or distributable net income, for those of you that have a tax background. Distributions of income do count and will carry over, if distributed to the beneficiary. Although there is an exception that if it's used to pay for medical expenses of a minor, they are not counted. What remains unclear, and on the S&A committee that I'm working on, man, we're really hammering on this, here is capital gains. There's language here that indicates that realized gains do count, although most of the language in the HUD regulations appear to not count realized gain. At this point, it's very unclear. If the trust owns an IRA and has required minimum distributions, once again, the question is that income or principal? My expectation is that it's going to be income here. And once again, the Housing Authority is still working on this. So there's talk about here determining eligibility based on other programs. The other part of that I'm not covering today, because once again, we really don't have clarity on this, is the old rules. We would always be looking for things that are not reoccurring payments. In the actual new HOTMA rules, They actually have more clarity on what is a reoccurring payments. We don't know for sure if that applies to trusts or not. We will figure it out as it goes. I will tell you, in most cases, for instance, with GSPT, even when on years where we get a good return, when you subtract out the administrative expenses and get ourselves down to just purely what is uh, DNI, the amount of income actually being distributed is probably going to be fairly minor. Takeaways, there now is an asset limit of $100,000 excluding the IRAs, $50,000 controlled um, by the family is no big deal. Regarding income, trust distributions of principal don't count, only if income, even if reoccurring, as far as we know, until we hear otherwise. If a D4A trust is funded by by an injury that funded it and it caused the disability, there's no special rules here. Enable accounts are not assets and are not counted no matter what. Okay. Now, let's see if we can put some of this together. As we get into this, just a few basics. When we're talking about special needs trust, it's kind of good to go through what kind of trust are we talking about. So just generally for special needs trusts and housing, if this for a third party trust, the source of the funds can be from anywhere but the beneficiary or the beneficiary spouse. It can be established by anyone except the beneficiary, and upon death, there are no restrictions, liens, or anything else upon death. Whatever the document says, that's what happens. For a D4A trust, here the beneficiary has to be disabled. Has to be under 65 when the trust was established. It can be established by a parent, grandparent, legal guardian, court, or the disabled individual themselves. And then there is a payback for any Medi-Cal used upon the death of the beneficiary before anything goes to the remainder beneficiary. For the D4C trust, you have to be disabled. Here, there is no age restriction, and it can be established by the beneficiary, parent, grandparent, legal guardian, or the court. And in the D4C trust, the Medi-Cal must be repaid, from the Medi-Cal lien from assets not retained by the trust prior to the remainder beneficiaries. This other table will help us as we go through our examples, is dealing with capacity. In a lot of cases here doing this work, we're going to have, we always have to be cognizant of capacity. So if we have a third party trust, is not subject to a conservatorship or anything along that line. For a self-settled trust, once it's established, that's not subject to a conservatorship. But if an asset is owned by the disabled individual and it's not held in a trust of some sort, if it's just held by the individual, if that individual doesn't have capacity or loses capacity, it could require a conservatorship of the estate, which is something we normally want to avoid. On home sales for third-party trusts, whatever happens to the sale, it goes back into the trust itself because it's an asset of the trust here, and it can be used for other things. In a self-settled trust, there's no issue, once again, because the assets can go back into the trust and be used to other things. If it's owned by the individual and it's not used to purchase a replacement home, it'll become a resource after 6 months. For the payback, once again, for third-party trusts, it's not an issue. For any of the self-settled trusts, of course, there's the payback to consider. And for if it's owned by the individual, there could be an estate recovery for any Medi-Cal used after the age of 55 by any assets that go through probate. We have a lot of folks that are watching this that are estate planning attorneys and fiduciaries. If you don't know how to create a trust to avoid probate, I think you need to go to square one. So one easy way to do that is to put it in a living trust and it won't pass by probate. Okay, with that in mind, once again, I did put many of the key POMs in your handout. So what Social Security says is the trustee of a special needs trust holds title to a house as a home for the beneficiary. The house would not be a resource to the beneficiary. And that would be the same if the beneficiary moved from the house. Once again, this is one of the reasons why I almost always counsel folks to put the house in a third party trust, even when the person has capacity, just to be able to have that latitude. So if the trust pays for other shelter or household operating expenses, these would come under these would be considered in-kind support and maintenance here. And then we would have countable shelter expenses. So here's our old friend again. Once again, what we're talking about is only these 10 items, and we're praying that the food goes away soon. But at the time we're recording this, the food is still an ISM issue. So getting back to this, if the trust pays for improvements or renovations to a home, they're not receiving income because improvements to a home here are not are once again not considered ISM. So that isn't a problem at all. By the way, taking a break, here is our last code. So our last code is 6923. 6923. Once again, to get the form to fill out to get credit, you need to go to gspd.org/attorney resources here, and that's where you can fill that in and send it in for credit. Okay, we're almost to the end, and then we can get to questions and answers. So let's kind of try to put this all together. So this is something, a scenario I call Mia's causes, Sue's causes, or providing a residence to maximize SSI and minimize liens. So let's say Sue wants to provide her daughter Mia a home to live in. Okay, sounds good. Here, Sue is concerned that if she puts the property in Mia's name, it'll be subject to an estate recovery. Now, in fact, if that were the only concern, then you could simply put it in a living trust and move on. Here, as I said, I think there's other reasons why it's best to put it in a trust, but that's an individual decision. Additionally, if Mia were someday were unable to live in the home and she sold it, it could interfere with her benefits eligibility. Once again, this is why my preference is to hold it in a third-party trust. Sue is able to purchase the home, and rather than give title to Mia, she titles the property into a third-party trust with no mortgage. Once again, obviously in the example of the mortgage is, even if it has a modest mortgage, we're probably going to have a problem with the ISM. So going back to the POMs here, what the POM says that if the trustee of a special needs trust holds title to a house for the beneficiary, the house would not be a resource, and it wouldn't be a resource if we moved. Therefore, the trust holds legal title to the house, and the eligible individual would be considered living in their own home based on having an equitable ownership under a trust. Now, before this was actually added to the POMs, what we ended up having to do before this equitable ownership concept here was that we would have to do our best to see if the beneficiary could pay us fair market rent, and then we would take that money and put it in the trust and try to use it for other things. In today's world, it would be almost impossible to do this. So what they're basically telling us is that an eligible individual does not receive in-kind support and maintenance in the form of rent-free shelter while living in a home which he or she has an ownership interest. And accordingly, an individual with an equitable ownership interest under the trust here does not receive rent-free shelter. So we're going to treat it as if she owns it, even though she doesn't. Now, quite honestly, that doesn't make a lot of sense to me, but I love the results, so I'd be the last one to argue with that. So if the trust pays for other shelter and household operating items, these payments would be income in the form of ISM in the month the payment is made. And once again, we have our site right there here if you want to look it up. So Mia can live in the house without paying rent because she has an equitable ownership interest. She's still going to have difficulty paying taxes and utilities without some sort of assistance. So Sue transfers enough funds into Mia's ABLE account, or in this example, if Mia were a trustee or a beneficiary of the Golden State Pool Trust, it can be transferred from her Golden State Pool Trust account here, either monthly or annually, to show to allow her to pay the taxes and utilities with no reduction in benefits. Just kind of as a comment here, um, um, Sue does not have to run this through a special needs trust to do this as long as she's alive. But obviously, she's going to have a problem when she passes away. So Sue also amends the special needs trust she created for Mia to direct the trustee to continue making contributions to Mia's ABLE account here in the event that she passes away or loses capacity. In many ways, the special needs trust really becomes the alter ego of Sue, mom, who in the end is going to be the grantor of either the special needs trust or the account here under or the account under GSPT. So Sue feels much more secure and feels that she's in the best of all worlds. Sue has provided a residence, and if Mia were unable to remain in the residence, the house could be sold and used for her needs without disrupting her eligibility for benefits. If Mia were to be sued, the assets in the special needs trust are protected because part of this is in a third-party trust here. It's a form of a spendthrift trust. So above and beyond keeping somebody qualified for public benefits, the other thing that this does do is it is a good asset protection tool. If by funding an ABLE account with what she needs when she needs it, then they've maximized any Medicaid lien that might be due upon her death and be able to once again pay for pay for her ISM issues and that kind of thing, and ideally be able to keep her benefits. Now, what if instead of a third party trust, this was a first party trust? Okay. A lot of times when I'm working with somebody with a first party trust, and should we hold the house in the trust or should we hold it outside of the trust? Part of what I'm concerned about is if the house is owned by a self-settled trust, it's going to be subject to Medi-Cal recovery upon death. And in all likelihood, the house will be lost. I try to do everything I can to not hold houses in self-settled trusts exactly for that reason, including court-monitored trusts. We are seeing many of the courts loosen up. I will tell you, it's in the past, it's been a very difficult thing to try to get many judges to hold the house, for instance, in a conservatorship or, for instance, in a trust here, maybe even overseen by the conservatorship here, so that the person with the disability can do what anybody else can do, hold the house and use it and be able to pass it to who they want upon death here or their heirs without Medi-Cal recovery. That was a heavy lift for many, many years. We're watching more and more courts that are getting it. I have to tell you, I've had too many cases where we've had parents who have given up their life to take care of a severely disabled child here. And the trust, under court supervision, purchase a house and the child passes away. And not only does the child do they lose the child, but they also either lose the home or they have a substantial lien on it. Once again, I want to do everything I can not to repeat that. So, getting to the end here, and we're going to get to the most terrifying part of the program, which is asking if you have any questions. For those of you that are doing this for credit, whether you're watching this live or you're watching the recording here, in order to get the credit, what you need to do is fill out the MCLE credit form here and all the other things that are required here and send that in. And once again, we will authorize the credit. So let's just go to the last slide here and let's see what we have here. Amy, I see at least 2 questions here.
Yep. Let me take. Okay, can you hear me now?
I can. And also just to give an old man a break, why don't you go ahead and help us figure out about these questions.
So first question, what does one do when a housing authority wants to count all distributions from a special needs trust, including distributions to an ABLE account? Worker told beneficiary that she was lucky to have a trust and just be thankful.
I have to tell you that I think there's a lot of good things that HOTMA did because the old rules had very little guidance at all, and all of that. We have more guidance, but we're just not. I mean, there still are some things that aren't clear. And I will mention this, especially for those of you that are on our mailing list, for professionals that are on our listserv here, and also those watching this. As things develop, we will do everything we can to make sure you get it first. So, how do you determine income and principal and that kind of thing? The most common sense thing is that we're talking about DNI, distributable net income. So the example would be, let's say, and this would be whether it's a third party trust or let's assume that we're talking about a third party trust. Okay, so from that we're going to subtract out, the administrative expenses here and that sort of thing, which will give us, in most cases, our DNI here, and then whatever is left, if there is income, common sense would say that, let's say what you did is you paid for attendant care services or something along that line here. Well, that income would, for HUD purposes, would carry out and become part of the countable income. But here's the part that we don't know. Okay. One of them is how do they treat capital gain? And once again, so far what we have is incredibly confusing. A number of advocates that I very much respect do not believe that capital gain would be counted, but we don't know that for absolutely for sure. The other part of that is, for those of us who have been doing this for a long time, we still have that reoccurring expense. What the HOTMA actually did is it better clarified what is a reoccurring expense. Because we used to do all sorts of crazy stuff. And we would try to pay expenses in no discernible pattern. So like we might pay the cable bill in month one, and then month three, and then month seven, and then eight. And I mean, just make it a hodgepodge. And a lot of housing authorities kind of went with that. A lot of us housing authorities didn't. Quite frankly, most housing authorities didn't count anything, no matter what you told them, but it was really confusing. There is a possibility they will still do the reoccurring expense. And the new rules with reoccurring expenses are basically if it's more than annually, it's a reoccurring expense. But if it's annually or less, it is not a reoccurring expense. Part of this is we have more clarity. Part of what we're some of us are doing, the Special Needs Alliance, the Alliance of Pooled Trust, and some other groups, is we're putting together some worksheets on this so that we can come up with how did we determine the income. My expectation is as long as you make a good faith um, um, attempt at reporting it, I think you're going to be fine. Okay. Um, in the 30 years I've been doing this work and 15 years as trustee, I have had two people lose their eligibility for HUD because of a trust. Neither one of them was with the Golden State Pool Trust. And quite frankly, those were folks with severe behavioral health issues, and they were looking for any reason to get rid of that rentor. Here, the vast majority of cases where I think they should have imposed an increase in the share of cost, it didn't happen. So um, I know that's mushy. It's less mushy than it was. I've got to say, for the vast majority of folks, when you get down to the actual DNI, the amount of income being distributed is going to be really minor.
Okay, just to summarize, but if somebody is trying to become eligible for HUD and they have an ABLE account, those resources should not be counted as income, correct?
That absolutely doesn't count. On top of that, something I should have put into the materials, which the materials can be found in the link that's for those of you that are watching this live. For those of you that are watching the recording, we'll make sure the link is there. There's a letter from HUD that is really useful to keep here, basically declaring that ABLE accounts do not count for HUD benefits. That can be very valuable. As far, one thing, getting back to HUD, is control outside of the household. Okay, now, unless you invite me to move in with you and you're on Section 8 here, and I've got my own home, so I don't need to do that. The Golden State Pool Trust, or if you have a private fiduciary, having the trustee outside of the household isn't an issue. Okay, here, the problem is if the trustee is a household member. Now, another question that's come up is what if the person is a beneficiary advocate? Okay, now we have no guidance on that. Okay, we have no guidance as to whether or not a beneficiary advocate that maybe is part of the household here is going to count. If we ever had a challenge from the housing authority, my answer would be that the beneficiary advocate is advisory only. Once again, a beneficiary advocate can make directions and and suggestions to their little heart's content. But in the end, I am the trustee, subject to oversight by the board here. So I don't think using common sense, that is a trust under the control of a member of the household, but we have no guidance on that and we have no cases on it. So that, a lot of doing planning, a lot of doing being a fiduciary is managing risk. It would be wonderful to live in a situation where there was no risk. But in a lot of cases, we are managing risk and we want to do everything we can to minimize that risk when we can. So that would be a consideration you might want to look at if maintaining HUD eligibility is of primary importance. Also, it says a trust not in control by the household. Doesn't say special needs trust. So a lot of what we're exploring, for instance, at the Dale Law Firm, is just creating what would be essentially a settlement preservation trust, make it irrevocable, have it hold the assets if we're not really concerned about anything other than housing authority here. And clearly by the regs, that should work. So there is some room for creativity, as with a lot of these things, you don't want to get too creative because you're dealing with somebody's benefits and their welfare here. But as we explore and as we share with each other, we'll find those safe harbors so that we can help persons with disabilities, be able to, live in their housing and not be afraid that they're going to lose it. Once again, losing eligibility for HUD is a disaster here. There is a lot of latitude with the housing authority, so I wouldn't get too paranoid, but on the other hand, I wouldn't get too aggressive.
Okay. First, open question. Distributions of income from irrevocable trusts are not under the control of the family, such as a third-party special needs trust, are considered income to the family, while distributions of principal are not considered income.
Right.
How does HUD determine what portion of a given trust distribution is income versus principal?
That's a good question. And we haven't really gotten a lot of guidance on that. So at this point, so I know folks have explored, can you elect to pay for principal? You may want to look at your own documents. In fact, there may be many of us that may be changing this. I think one thing to keep in mind, though, is even if the fair share for the recipient goes up because of the trust, so long as it doesn't go up to the point that it makes them ineligible, which is 50% you have to be below 50% of the federal poverty rate. I believe that's what it says here. It means that your share is going to go up slightly. It's not the end of the world in most cases. As far as absolute clarity about if your document allows you, can you just declare that this is principal here and not income for the distribution? We actually don't have guidance on that, and we have no cases. By the way, there are very few cases on HUD, which also makes us a little anxious. There is no National Academy of HUD attorneys, because there isn't. So, sometimes dealing with these HUD rules can get a little wonky.
Okay, I'm going to pitch you an easy one, and then we'll go back to a hard one.
Okay.
Okay, if an SSI recipient's check is not sufficient to cover his share of shelter and food costs, but agrees to pay his entire SSI check towards these costs, is there a reduction in SSI? So is there still an ISM reduction even if the recipient pays as much as he can?
Well, actually, this is where that example that we saw earlier really helps us. So being a little indulgent, let me just do this real quick. That's one thing that I do like about not only a lot of the materials that they put out by Social Security. Here, is this the example I'm looking for? Oh no. Oh, I'm sorry. Okay, let's find the correct example. Um, well, okay, in this example, once again, this would be pretty much true in this example. So let's say instead of $400, I mean, this person does not live in San Francisco. That's pretty clear. Um, here. But let's say that what the person on SSI has is the $1,100 and their fair share is $1,200, right? Um, what's going to end up happening if they use their entire, um, um, if they pay the entire amount, but it still doesn't cover their fair share, then they're going to be assessed in that example. I've already forgotten my numbers, but there will be an ISM. It probably wouldn't be $314.33. It might be $100 or something along that line. Does that answer the question?
Well, I think you might want to add that if the ABLE account paid for the rest versus the family member directly, then there would not be, correct?
Yeah, I know we run into this all the time when we're dealing with, a lot of the cases that those of us who do this work get is we get a lot of the birth injury cases where we'll have a child with a severe disability here who's going to need an enormous amount of care. And oftentimes the parents will step forward here and keep them in the household. And so then the issue in that case is the child is definitely part of the household. And let's say the child is getting SSI, we're trying to get every dollar we can into the household. And so a lot of what we're doing in those cases is we're doing our best here. Um, well, what we do in those cases is we will do a calculation of what is their fair share based on, once again, the 10 items they count for ISM. And and oftentimes the SSI will be inadequate to to do that. Like if your ISM is once again, if it's $1,500 and you only have $1,100, so you're $400 short, right? So one thing a parent can do is contribute $400 a month or enough to maintain that into their child's ABLE account and then turn around and take that ABLE account, because the ABLE account at that point, even if the parent is in charge, is the person with signature authority, it's owned by the child here. So then we take that same $400 and turn around and pay the parent back that $400 here, so that the child can pay the entire amount of the fair share. And we've done that many times and it works. Okay. I mean, it's a little convoluted, and we are definitely laundering money here, but it does work. The problem is, especially living, for instance, in the San Francisco Bay Area, those mortgages are oftentimes so out of whack, it just throws the number um, to something that we just can't make it work, and you have to deal with that. Anticipating something that I don't know if it's in there or not, but if there's a CPA in the room, okay, in that situation, if the parent put $400 in an ABLE account and then has the child is basically paying rent back to the parent, Is that taxable income to the parent? And I'm going to duck on that one. That's one where you should seriously talk to your CPA here, because in a lot of these scenarios, we're all covering income as far as benefits are concerned, but we don't really have the bandwidth to get into income as far as benefits are concerned. So there we go.
Okay. This one seems complicated.
Uh-oh.
Can you clarify income deeming exceptions associated with medical expense reimbursement? HOTMA per section 5.609 appears to count third-party SNT distributions of trust income made for the benefit of a voucher holder as income to the voucher holder, even when these distributions are paid to third parties for medical expenses of a family member, with the sole exception of medical expenses for a minor. However, later in the section, any amounts received by the family from any source that funds medical expenses for any family member, regardless of age, is not counted as income.
Uh-huh. And look, who asked that question?
You really want to know? Do I have to disclose?
Oh, I don't know. Okay, we don't
Karen,
have what?
Karen Mulvaney.
Oh, Karen. Okay. So,
Would you like to speak, Karen? We
well,
can
not that I want to rat Karen out, but
Okay.
I have this, you know what? I have exactly the same question here. And there are other things that are not clear at this point, and we're going to have to wait for guidance because what it says is reimbursements for medical expenses. Well, that's basically what we do here is that let's say the person uses a TrueLink card, right? And they rack up the stuff for medical expenses and we pay off the medical expenses. I think logically that's not income. Am I 100% confident? Karen, if you have a client or a beneficiary who tests this out and you have a problem, let us know so we'll all understand it. The other one is reoccurring expenses, right? You think, does this mean now that we are not going to be dealing with medical expenses in the future? Not medical expenses, reoccurring expenses? I'm not so sure that's true. I think in a lot of cases, we get a second bite at the apple. If, for instance, let's say what we're doing is we're paying for the annual car insurance and we pay it annually. And if you look at the new rules for reoccurring expenses, if it's paid annually, it's not a reoccurring expense here. So do we get a second bite at the apple and the person can declare that despite the fact that with the DNI, an amount that was distributed was income, but it was used to reimburse. I mean, it was used for a non-reoccurring expense. Does that get us a second bite of the apple? I think it does, but I don't know for sure. And I know for many of us who do this work, when we're talking to beneficiaries and we're talking to clients, I know they don't want to hear that I'm not sure, you know. I'm not sure.
Okay.
I think logically, though, there's a good answer. And also, Karen, I'm sorry we ratted you out. I was just curious. Oh, she either raised her hand here to say thank you or whatever. Okay.
We can allow you to talk. Would you like to talk? Let's see here.
Sure, it's Karen Mulvaney. No problem ratting me out. I ask questions all the time.
You're a very inquisitive person. Anyway.
I agree with the very confusing nature of the guidance from HOTMA to date, and some new HOTMA training webinars are saying if the HUD beneficiary doesn't expect a trust contribution to recur, it should not be counted as a source of income for the next year. And so it's not the trustee's expectation, it's the beneficiaries' expectation and how, when you're dealing with developmentally disabled individuals who may not expect anything, how is this going to be addressed? It's a puzzlement.
It is a puzzlement. Although, if they made the stuff easy, we wouldn't need attorneys and fiduciaries. And what kind of a world would that be? But I will mention this one thing. And, part of it is the value of being part of a community. I mean, one of the reasons we're even doing this program at all is that, with the Golden State Pool Trust itself, there's a couple of principles that we have. And one is that on all first party trusts, we want folks to be counseled before they get it by knowledgeable attorneys. We want to be able to get that information out there as best we can. We also maintain a listserv, which we just restarted. So for those of you that are not on the listserv, feel free. And if you're a professional, this is not for family members. I'm sorry. Here we have other things to help you, but feel free to email steve@gspt.org and we'll put you on the list. The value of that is, as we get these training materials and things like that, we can keep each other up to date with our experiences and all that, so we can all learn together, right? But there are a lot of unknowns with this, but basically we're looking at either exempting it at the trust level or at the beneficiary level here. So and there is still some fuzziness out there. And we have 4 more minutes, and then we will officially be over here in that, and we will have met the requirements of the state bar. I will stay on afterwards, but we got 4 minutes to go. Amy, do you have a 4-minute question, kiddo?
I think this one could be. Is there a maximum for the distribution from principal before they count as income?
It depends on what your trust says. Of course, I don't anticipate HUD is going to be digging through trusts. So most of the trusts we have is going to say we distribute out income first and then principal, right? But it doesn't have to say that. I mean, I'm involved in advising on the Wealth Council Trust. I can imagine we may be looking for options where we could vary that. My anticipation is the number of cases where that's really going to be a big issue is not going to be as big as we think about it, but it depends on what the trust says. So
I'm
Tim
going to
has a question.
I'm going to let him speak. Let's see.
And be careful to put your hands out. We're going to.
I believe you should be allowed to speak.
Oh, well.
Oh, I lost him. All right. I'm sorry. I tried. And here's another quick one. Are there any other rules on HUD that have changed recently? You mentioned AB 133.
Well, AB 133 is Medi-Cal and Medi-Cal only, right? I mean, quite frankly, that's the heaviest lift at all. Although, let's just look at this. When we're making distributions, the distributions for Medi-Cal, if they're not SSI based here, once again, we're dealing with share of cost. So we have to be cognizant of the income being distributed from the trust so as not to throw the person into a share of cost. The concept is similar but vastly different when we're dealing with HUD, right? Because in that case, we're not talking about share of cost. We're talking about whether or not there's going to be an increase in their contribution. So, and then we have SSI on top of that, which deals with income in a totally different situation. If we really wanted to make one's head spin here, when we're talking about distributions of income For tax purposes, we're talking about another thing. So this is getting really more and more complex.
Now, I believe Tim should be able to speak now. If you want to try again. Tim, are you there? Okay, I don't know. Okay, so
let's just do this one last one. And then once again, I will declare this over, but I will stay online.
okay, will receipt of an inheritance create income?
For HUD?
The question was just, will receipt of an inheritance create income?
No, actually, what it says specifically is lump sum payments are not considered income. But then the problem is, let's say that, let's say what we're talking about is $150,000 inheritance. Okay, the month you receive it, I mean, it's not going to be income. But now you just went over the $100,000 resource limit for HUD. So you're probably looking at either trying to put it in an enable account. Remember, they don't count IRAs. I mean, if you could put some of it in a qualified plan, you could do that. Um, I'm not really prepared to discuss transfers for less than fair market value. I know that there can be some severe penalties, but quite frankly, I'm not really prepared to discuss that today. Giving it away, you've got to be really careful. You're going to, at least if you give it away, they're going to apply the passbook rate on it. So that's something where for those folks, in that example, you might want to take some of those funds and put it in a trust, not controlled by the household. So in the $150,000 case, now remember, there's almost no accountability for less than 50,000. So maybe they want to just keep the 50,000 and put the rest in a trust. Could be a third party trust. I mean, no, it can't be a third party trust. Could be a special needs trust. Could be a settlement preservation trust here, but it would have to be controlled by somebody outside of the household. So in a way, that's kind of putting the things we learned together and putting the pieces together for a solution that, at least in accordance with the guidance we have on March 26, 2024, how we might handle that. Amy, with that, I think we have hit an hour and a half. I think at this point, I want to just officially thank everybody for joining us. A couple of things. One is, if you're watching this and you are not on the GSPT mailing list, once again, you can go to gspt.org to attorney resources and sign up there. If you really need help, you can also always email amy@gspt.org. The other thing that I want to make a little pitch on is that we're really trying to focus a lot on serving people with intellectual and developmental disabilities. And we're going to be making a big push for folks to take the Keep the Lanterman Promise program here. And for those who complete the program, if you're a private fiduciary or attorney, we will put you on a list that will be available to folks to know that you at least took the class. With that, I want to thank everybody for attending today. And that is our official end.